During a court trial, witnesses do not simply narrate facts on their own. They are questioned according to a legal procedure prescribed under the Bharatiya Sakshya Adhiniyam 2023, earlier sections 137 and 138 of the Indian Evidence Act 1872. These stages are examination-in-chief, cross-examination and re-examination. Their purpose is to bring out the truth, test the credibility of witnesses and help the court reach a fair decision. 1. Examination-in-chief. Meaning, examination-in-chief is the first examination of a witness by the party who has called that witness before the court. Purpose: to place the witness's evidence before the court. To prove the facts supporting that party's case. To introduce relevant documents and evidence. Simple example, in a theft case, the prosecution calls a shopkeeper who saw the theft. The prosecutor asks the shopkeeper what he saw. This is examination-in-chief. Important rule. As a general rule, leading questions suggesting the answer, are not allowed during examination-in-chief unless the court permits them for introductory or undisputed matters. 2. Cross-examination. Meaning, cross-examination is the examination of the witness by the opposite party after the examination-in-chief. It is considered the most effective method of discovering the truth. Purpose: to test the truthfulness of the witness. To find contradictions or exaggerations. To test the witness's memory and observation. To expose bias, interest or falsehood. To weaken the opponent's case. Simple example, after the prosecution examines the shopkeeper, the defense lawyer asks whether it was dark, how far away the witness was standing and whether he clearly saw the accused. This is cross-examination. Important rule. Leading questions are generally allowed during cross-examination because they help test the accuracy and credibility of the witness. 3. Re-examination. Meaning, re-examination is the examination of the witness by the same party who originally called the witness after cross-examination. Purpose: to explain matters raised during cross-examination. To remove confusion or contradictions. To clarify doubtful answers. Re-examination is not meant to introduce completely new facts. If new matters are introduced with the court's permission, the opposite party gets the right to further cross-examine on those new matters. Simple example, during cross-examination, the defense creates confusion about the lighting at the place of occurrence. The prosecutor then asks the witness to explain why he could still identify the accused. This is re-examination. 4. Order of examination. The law prescribes the following order: examination-in-chief, cross-examination, re-examination. This order ensures that each party gets a fair opportunity to present and challenge evidence. 5. Value and importance of these examinations. A. Examination-in-chief places relevant facts before the court. Helps establish the case of the party calling the witness. Introduces documents and other evidence. B. Cross-examination. Tests whether the witness is truthful. Detects falsehood, bias or exaggeration. Protects innocent persons from false evidence. Helps the court assess the credibility of the witness. Strengthens the principle of fair trial. C. Re-examination. Clarifies doubtful answers. Removes misunderstandings created during cross-examination. Ensures that the witness's evidence is properly understood. Together, these three stages help the court discover the truth and deliver justice. 6. Rules governing these examinations. The important rules are: witnesses are examined in the order prescribed by law: examination-in-chief, cross-examination and re-examination. Leading questions are generally not allowed in examination-in-chief and re-examination, except with the court's permission for introductory or undisputed matters. Leading questions are generally allowed in cross-examination. Cross-examination may extend to all relevant facts and may also test the witness's credibility. Questions intended only to insult, harass or unnecessarily embarrass the witness should not be allowed. The court may disallow irrelevant or improper questions. Re-examination should normally be confined to explaining matters arising out of cross-examination. If new matters are introduced during re-examination with the court's permission, the opposite party has the right to cross-examine on those matters. Every witness must answer truthfully after taking the oath or affirmation, except where the law grants a valid privilege. Case Study, State of Rajasthan v. Kashiram, 2006. In this case, the Supreme Court emphasized the importance of cross-examination. The court observed that the credibility of a witness can be properly tested only through effective cross-examination. If a witness's testimony remains consistent even after detailed cross-examination, it becomes highly reliable. Conversely, serious contradictions revealed during cross-examination may reduce the evidentiary value of the witness's statement. Simple understanding: if a witness speaks the truth, careful questioning usually does not change the story. If the witness is lying, cross-examination often exposes the falsehood. Conclusion: Examination-in-chief, cross-examination and re-examination are three essential stages of recording evidence. Examination-in-chief presents the witness's evidence, cross-examination tests its truth, and re-examination explains any confusion. The legal order is first examination-in-chief, then cross-examination and finally re-examination. These examinations ensure fairness, protect the rights of both parties, and help the court reach the truth.